Good evening, class. I'm not sure whether it's morning, afternoon, or evening for you all seeing this. It's the evening for me. I think I mentioned to you that I've been a little under the weather recently, and so I'm getting at this a little later than I wanted to. But in any event, I want to take up a couple of administrative matters first, and then we can get on with the lesson. First of all, on the discussion board for this week, you will see that the syllabus refers to page, I'll flip over here, it's on page, let me find this for you here. It's actually on page 54. It's called Reviewing the Court System. And it involves a Ronald Metzger, who's the plaintiff. It involves a young child choking to death in its crib. But really the issue has to do with attorney's fees. So you'll read a little bit about lawyers' contingent fees in the chapter. And where I want you to focus, though, is on the debate this. So there are actually 4 questions there. And I'd like you to just answer questions 1 and question 2. Just answer questions 1 and 2. Don't be concerned with 3 and 4. Then what I want you to do is to deal with the debating issue of a cap on lawyers' contingency fees. Some quick background on that. There has been a feeling among many consumers in particular that lawyers' contingent fees are too high, that they take too large a chunk of the money. When I go through, we go through trial practice and all the pieces and phases of a trial, you'll see there's a great deal of work involved. So it's not like the lawyer's not doing anything. He's doing quite a bit as the case goes along. The issue arises when the lawyer gets a fairly quick settlement on a case, and the amount of work that had to go into doing that might not be as enormous as the fee might turn out to be. So we'll talk about that in more detail. But what I want you to do in making your in writing about your decision here, your opinion, is I'd like you to get online and you can Google lawyers, attorneys, contingent fees, and I'd like you to find something on the issue. In other words, I'd like you to find a news article or whatnot. Just find something like that that you can mention in your discussion board. So while you're going to answer quickly questions 1 and 2, which should take little or no time, then the more lengthy part of the discussion board will have to do with this issue of contingent fees and whether the government ought to be capping them, whether they ought to be putting a limit on what attorneys' fees can be in a contingent fee situation. In other words, how much? Should it be 5%, 20%, 50%, what have you? And I'll go over that with you in more detail when we get through the trial, start going through the trial process, and I can tell you about how we go about fixing fees and the various types of fees that are out there depending on the nature of the work to be done. So that is the first item. The second item, I did get an email from one of your members, and again I want to speak to my email where I reallocated points for the quizzes and for the research papers. So now the research paper is worth 360 points, and the quizzes are worth 40 points apiece, or 120 points total, which would amount to 12% of your grade. I did that, as I said in the email, because I think that more emphasis is certainly on the research paper, and you ought to be rewarded more because there's a lot of work that I'm hoping you'll put into that to give me a good work product. And in the meantime, the quizzes, certainly they're there to have you look at and review the material, but they're not extensive, they're not lengthy, and if you do real bad on a quiz, the way I have it weighted now, I think it can adversely affect your grade in an unfair way. So we've made those changes. They're in the syllabus. If anybody has any further questions, they're in the email rather. So if anybody has any questions, certainly shoot me an email on that, and we'll clear that up. The quiz will be ready for you by the middle of the week. As I said, it's very brief. And so there's just a true, false, and multiple choice, 5 multiple choice, and 15 true, false. So it's really not a great deal. Okay, now on administrative law. Administrative law is not my favorite topic, and I'm sure if you did some of the reading, it probably is not yours. I am going to go through it, but not tonight. I'll touch on it, but again, there's not a lot of meat there. But you do need to know what administrative law is about, and we'll go through that. And if we don't have enough time tonight, we'll do it then. But I'm primarily going to focus on the assignment for, today, which is, or for this week, which is Chapter 2, the court system, and Chapter 3, which is alternate dispute resolution, which you'll find is a topic that I'm very passionate about. And it comes from my experiences being in private practice and seeing what I think some of the issues are in the court system as it relates to providing services for us everyday citizens who may have a dispute and take it to court and find ourselves in a nightmare situation. So I'll go over alternate dispute resolution for you as we get to that point. So we're going to start with Chapter 2. And I'm just going to start with the first page, first section, to just do a quick introduction. And then we're going to skip over to Section 3, which has to do with the court system, the federal court system. I don't like the way this thing is set out, and so I'm going to move away from the way it's set out here. And so we're just going to go to page 37 after I give you some preliminary remarks, which are really not necessary for you to take much in the way of notes on. So Section 1 is on page 28. We're going to skip over that after I talk about Section 1 quickly. We're going to come back to basic judicial requirements in Section 2. We'll come back to that. So let me start by saying the American judicial court system, the concept that really upon which the entire American judicial system is built is the idea of judicial review. We have a trial system. That is, when people have a dispute, they go to court, or they hire a lawyer and they go to court, or if they go to small claims court, you can go by yourself. We'll talk about that in a second. And then they go to the court, have the case heard, and based on the testimony and whatnot, they'll end up with a verdict one way or the other. That's just where it really begins, because from that point on, you then have the ability to appeal your case to various levels. And that is called judicial review. And the idea of judicial review is that there's a higher court that will review what the outcome was of your case at several levels, with the idea being that you'll get a chance to determine whether you were treated fairly or the verdict was right. Now understand, of course, that anyone who loses is not going to think the verdict is right, but that's the way the system works. But at least if you don't think it's right, you have a chance to appeal it to another level and further if you like. And there are some cases that will start as a dispute over a county ordinance or over a municipal ordinance that go all the way to the Supreme Court of the United States, not just the Supreme Court of California. So this is what the court system is all about. The interesting thing, if you want to call it that, is that the Constitution, nowhere in the Constitution does it give the courts the right for judicial review. In other words, there is nothing that says that matters of law that are in dispute can be reviewed by a higher court. That was established in probably one of the most famous cases, or most famous cases for lawyers, called Marbury versus Madison. It's in your textbook there in Section 1. Decided in 1803, which is really 15 years or so after the country was founded under the Constitution. And in that case, Chief Justice John Marshall, who was the first Chief Justice of the U.S. Supreme Court, basically held that the Supreme Court of the United States and its lower appellate courts have the authority to determine whether laws are constitutional or unconstitutional. Basically, he took the bull by the horns. He basically stepped up and said he made them an equal player in this three-element government of legislation, executive, and judiciary. Up to that point, it was completely unknown as to just how much power the judiciary would have. So under this Marbury versus Madison case, 1803, The Supreme Court of the United States established the concept and the right of judicial review, and that is reviewing decisions of lower courts. And the ultimate review is the U.S. Supreme Court. There's nowhere else to go after that. If you take your case all the way to the U.S. Supreme Court and you can't win it, you're finished. You're also probably broke. So anyway, that's the idea of judicial review. Now, the next section deals with judicial requirements, jurisdiction, and so forth. I think that's in the wrong place in the textbook, since we're talking about the court system, and we're going to talk about a trial and the process of going through a trial and so forth, and going through a lawsuit and then a trial. So in that case, I'm going to have you flip over to page 37, I think it was, and you'll see there in Exhibit 202, you'll see a diagram of the court system. And that's really what the court system is. You'll see to the left is the U.S. Supreme Court, and coming down from the left to the left side there is the U.S. Circuit Court of Appeals, and there are 13 circuits. And then there's the federal administrative agencies, the U.S. district courts, and then the specialized U.S. courts. Okay? Now, on the right, coming down from the right side of the Supreme Court, is the state Supreme Court, would be each state Supreme Court. Then you have that state's Court of Appeals. Then finally you have the state trial courts and state administrative agencies. And then finally the local trial courts of limited jurisdiction. Okay? So let me tell you where they're parallel. I would have done it a little different, but this is how they're parallel. If you look at the U.S. district courts, and if you look at the state trial courts of general jurisdiction, they are on the same plane. Only one is federal, the other is state. That's where cases are tried. So if you have a federal kidnapping case or a federal bank robbery case, it's tried in the U.S. district court in the jurisdiction where that happened. So if it happened in Santa Ana, it's going to be tried in the federal district court that happens to be in Santa Ana, and that would apply for a case that occurred down in San Diego, would end up in the federal district court. In San Clemente, it would be up in Santa Ana in the federal district court. Likewise, state trial court, which is the third box down on the right-hand side, you'll see that deals with trials in the state level. So automobile accidents that occur where the parties are from the same state will be held in the local court, which the Superior Court of California for Orange County is in Santa Ana also, in that big, huge court complex if you've ever seen it. So you have federal courts there, and you have state courts there as well. That's kind of the court center for our area here in the Orange County area. Now, let me tell you a little bit about how they work. You'll have the U.S. District Court, and I think there's about 150 or 160 districts. So, for example, in Pennsylvania, where I practiced law early on, we had the Eastern District, the Central District, and the Western District. If you're familiar with your geography, Pennsylvania's pretty much kind of a square, rectangular shape. And so they basically cut the state in thirds, and so the Federal District Court for the Eastern District's in Philadelphia, the Central District's in Harrisburg, and the Western District is in Pittsburgh. And so various states, California, I'm sorry to say I can't tell you exactly how many districts we have, but the size of our state, I would suspect we probably have 5 to 7 various districts because of the length of the state. For the U.S. district courts, that's where the trial court level, okay? Then you have a case that's lost at trial at the U.S. court, U.S. district court, goes to appeal to the Court of Appeals, and they call them circuit courts. So they're circuit courts of appeal. And the Circuit Court of Appeal in California is the 9th Circuit. And so now I'm going to ask you to flip over one more page to page 39, and there you'll see a map. And it shows you a map of the United States, and it shows you the 9th Circuit. So the 9th Circuit for the U.S. federal court system encompasses Nevada, Arizona, Washington, Oregon, Montana, Idaho, and of course California. So those states, any case tried in the federal district court of any of those states that goes on appeal goes to the 9th Circuit Court of Appeals. And the 9th Circuit actually sits in San Francisco. Okay. You'll see here there are 13 various, so the states are kind of grouped, as you can see. There's looks like two groups of southern states here. We have South North Carolina, Virginia, and then you look a little further south, you've got Georgia, Alabama, and you have Florida. And so you'll see the various circuits. Now, there's characteristics of these circuits. These circuits reflect, the decisions coming out reflect very often the views of the people who make up those circuits to a large measure. The Ninth Circuit Court of Appeals is known to be one of the more liberal courts of appeals, meaning that they tend to if I had to pick, maybe they side more with the individual than the company, or they're stronger on individual rights versus governmental rights. It's those sorts of things. Whereas, and I think you would suspect, if you're in the Midwest and if you're in Iowa or Missouri or Minnesota, Nebraska, those areas tend to be much more conservative. So they're in the Eighth Circuit. And then lastly, the Second Circuit is considered a very liberal circuit. That's New York, Massachusetts, some of those states. So you've got kind of there's always been kind of a East Coast, West Coast, where populations are pretty dense. They tend to be, those circuits tend to be a little more liberal. In the middle of the country, they tend to be more conservative. And if you go down to Texas, which is in the Fifth Circuit, they get about as conservative as I think you can get, if you've read your newspapers. So it kind of reflects a cross-section of people's views of things. And I'll go right to a reason why the Supreme Court, why it has such an important function. Here's why. Let's take the issue of same-sex marriage. As you know, a number of states have made it legal, and a number of states have not. There are 20-some states that forbid it, and I think 5 to 7 that so far have authorized it, and the others have not made up their mind, apparently. But in any event, here's what happens. If you have a case in California, and that case is decided by the jury or by a judge, taken up to appeal to the circuit court, if in the federal court, if the Circuit Court of Appeals makes a decision, that decision is binding on all those states in the Ninth Circuit, but it is not binding on any other state that's not in that circuit. So you can see what happens. You can have a case in New York where the Second Circuit comes up with a decision, and maybe the Ninth Circuit's decision is different. Or certainly, let's say, in same-sex marriage, most of the states in the Eighth Circuit do not permit it. In Middle America, Texas, Fifth Circuit doesn't permit it. Whereas in New York, Massachusetts is part of the Second Circuit, they permit it. So what you have then is an inconsistency of the law as it applies to the country. And so what happens is the Supreme Court, then the parties will appeal to the U.S. Supreme Court after the circuit courts have made decisions. And the Supreme Court may elect to hear the case, they may not. Often, though, they will hear a case because they feel that it has nationwide ramifications, and they'll look at it from the standpoint that it may require a single determination in order that things can be consistent and predictable and as one would expect throughout the whole country. And I think I mentioned in the last lecture about a same-sex couple going to a state that doesn't recognize same-sex marriage, and then one of them dies, and then all of a sudden they can't inherit anything. I'm pretty sure I went through that. In any event, it's the same situation here. So with same-sex marriage, what you've got is you've got the Ninth Circuit and the Second Circuit in New York. Those two have said it's fine. And yet the Eighth Circuit, Fifth Circuit, the 11th, a number of the other circuits have said it's not fine. So they say it's not legal. That law is not legal. And the Ninth Circuit says it is. So that's why that case has gone to the U.S. Supreme Court, because the decision of the Fifth Circuit in Texas saying it's not legal is not binding on California or Oregon or Nevada. Likewise with New York. So I think you can see this issue with the court. Now, turn back to page 37, and you'll see we've got here the federal administrative agencies, and that's the part I'll get back into later on, either later today or at our next lecture. There's not a whole lot of meat there, but you need to understand this, that what happens is Congress passes laws and then gives the authority to various agencies to implement those laws, and they're implemented through regulation. And those regulations then have to be administered, hence the word administrative law. And so many times you'll have a regulation that is often has the force of law, and someone violates that regulation. And then you have a whole series of processes that involve a hearing, evidence, witnesses, not like necessarily a courtroom. Very often you have what's known as an administrative law judge. And most of these things are heard without a jury. There's no requirement to have a jury. And so there are administrative agencies that hear these challenges to these regulations. And you'll see there, if you look at the box, those can be appealed up to the U.S. Circuit Court of Appeals. Likewise, the state administrative agencies may come out with a decision that is not satisfactory to one party. They can then take that appeal up to the California Court of Appeals, and from there you can see it could go up to the California State Supreme Court, and from there, if there's a federal question, okay, a federal question meaning you've got to be able to show there's a constitutional issue. You can't just go there because you didn't like the way the outcome was. It's got to have some bearing on the U.S. Constitution to get to the U.S. Supreme Court. So that's the other route to the U.S. Supreme Court through the state court. So you'll see way down at the bottom here on the right-hand side, local trial court of limited jurisdiction. So this is where the little tiny cases, ordinance cases and whatnot, may come up. And they may be challenged. And if they're challenged, they get appealed to the state trial court level by a judge there will hear them. Then it could go to the state court of appeals, then to the state Supreme Court, and then to the U.S. Supreme Court if there's a constitutional issue in there. What would be an example? An example would be a zoning ordinance. Let's suppose the city of Orange passed a zoning ordinance about some activity that they're going to prohibit. And the person who has a business that's performing that activity gets fined, and they decide to challenge that fine because they say you can't put that kind of regulation on my property. I'm a private property owner, and the government has no authority to do that. So that starts at the level of local ordinance in a small courtroom. That case, and there'll be groups that feel strongly that will support the costs, that case can find its way all the way to the U.S. Supreme Court because the constitutional issue is a person's right to private property over the right of a state or an agency, a governmental agency, to exercise governmental control over your private rights, your private ability to pursue your health, your happiness, and your general welfare, so to speak. So you can see how a little thing like that, and it happens, can go all the way to the U.S. Supreme Court for adjudication. How long would it take? Probably 3 years, maybe 4. Take a long, long time. But it can go from the very, very bottom all the way to the top. Okay, so that's the court system, state and federal court system. They kind of run parallel, but the jurisdictional requirements are different, and I'll talk about those in just a second. I've talked about the circuit courts of appeals. Just like you to know what I've told you about them, which is the decisions of one are not binding on the other circuits, that there's only 13 circuits, and that their appeals go to the U.S. Supreme Court. In the federal system, the next stop, if you get an outcome on any of these districts, these circuit courts that you don't like, these circuit courts of appeals, they all go to the U.S. Supreme Court. But when I get to the Supreme Court, you'll find that they have to be accepted by the Supreme Court. The Supreme Court has to agree to hear the appeal. And the Supreme Court is very, very stingy about hearing appeals. Okay? All right, so now let's go back. Let me make sure I've gotten everything I want to get out of the way on that. Let's go back now to page, it's section 3 on page 29, and it talks about basic judicial requirements. So let me talk about those for you for a minute. You've got the court systems, and the way the system works, though, is that the court has to have a number of things in order to hear your case. And so when I say the court, let's say we'll talk about the Orange County Superior Court, which is the trial level for the state, or we'll talk about the Federal District Court for the Southern District of California, which is going to be Santa Ana. So you can have a case that occurs, and the question is, what court does it belong in? Can it go to the federal court, or must it go to the state court? Okay, those are the kinds of questions. And so the law has created what's known as jurisdictional requirements. And there are basically three. One is jurisdiction over the person. The second one is jurisdiction over the property. And the third one is jurisdiction over the subject matter. What's the case about? Whatever it's about will determine what jurisdiction, what court. So when you're talking about jurisdiction, you're talking about what court the case goes to. Meaning, if you're going to file a lawsuit, it has to be filed in the right court that has jurisdiction over that. Okay. A real quick, easy example is if you have an argument over a piece of real estate in New York, and both parties are in New York, they can't decide to come to California because they want to get out of the winter and file the lawsuit in the Superior Court in Orange County. The place for that lawsuit to be filed is in the state court in the county where the property is located. Okay, so you've got to meet these requirements to file in the various courts. So let's talk about jurisdiction over the person. The court has to have jurisdiction over the person, and in that case we call it in personam. It's called in personam jurisdiction, and it basically says that generally speaking, for example, in a domestic relations case, in a family law case, if the parties reside in Orange County, if they live in Tustin, or they live in Corona del Mar, or they live in Buena Park or Westminster, where they reside is the proper jurisdiction for the state court, and that court is the Superior Court in Orange County, California, in Santa Ana. So that's where their case would be filed. Jurisdiction over the person. Now, there's a thing called long-arm statutes. And what long-arm statutes are is they are statutes passed by each state, and the simplest example is automobile cases, where you have automobile injury cases. I can be driving to visit my daughter in Pennsylvania, and I can have an accident in Pennsylvania and turn around and drive back to California after my visit. And I had this accident, and I was at fault, let's say, and the person that was injured lives in Pennsylvania. They will file their lawsuit in Pennsylvania, and even though I don't live there, I must submit to their jurisdiction under this concept of the long-arm statute. And the long-arm statute basically says that the state of Pennsylvania gives me permission to operate a motor vehicle in their state. However, by doing so, I submit myself to their jurisdiction. I can't claim that I don't live in Pennsylvania, so you can't file that suit in Pennsylvania. I was there. I was operating a motor vehicle. A long-arm statute says that that state court can take its long arms out, reach out and get me in California. When I say get me, serve me with the complaint, and now I better get myself a Pennsylvania lawyer really quick, because there's going to be a case going in there against me, and if I don't defend myself, I can find myself with a big judgment against me. So that's the long-arm statute, and every state has them for various types of activities, but the most common one that everyone certainly understands has to do with automobiles and operating automobiles in various states. Okay? The next area of jurisdiction is called over the property. That's called in rem, R-E-M. You'll see it in your book there. It's called in rem jurisdiction. It's jurisdiction over the thing, and that's the property. Okay? So let's go back to my example of I live in California, and I'm involved in a real estate transaction with someone in New York. There's a piece of property in New York. We've entered into a contract. Maybe I'm going to buy the property from him. Maybe my company does work there and on properties of some kind. In any event, we get into a legal dispute. Okay, we get into a dispute. And I get mad and I file my case in California. Well, under the concept of in rem jurisdiction, the fellow in New York is going to file a motion. He's going to call a lawyer out here to file a motion to dismiss my case and direct that my case be sent to New York, because that's where the property is. And that makes perfect sense, because if there's going to be issues about the property, then The jury may have to go out and see the property. The evidence about the property is out there. Photographs are back in New York. Everything that's really centered around that controversy on that piece of real estate is in New York. So why would I be allowed to have that case filed in California? I wouldn't. So that's the idea of in rem jurisdiction, wherever the thing is. Okay, now you can even probably have, I would think, let's suppose you have a motor home, I'm sorry, a mobile home, or we call them manufactured houses now. And it has on wheels, but it's been taken to Florida to a retirement community. The wheels have come off, it's been set down on a foundation. It's now been attached to the property. Okay. Now it could be picked back up and moved back to California, but at the time of the dispute, it's on the ground there and it's been converted as to a piece of real estate. Any dispute between the property owner of that manufactured house in Florida and anybody else is going to be in Florida. It's not going to be where, let's say my company built the manufactured house and we transported it out to Florida, where the party who bought it erected it for their home. The place, and so they say there's defects to the house. The roof leaks, the structure's infirm, whatever it might be, the electrical is not properly installed. I have to defend myself where that property is, okay, because that's now located in Florida. That's called in rem, all right? And then the last one is subject matter jurisdiction. And I think if I'm not mistaken, on 37, on 37, you'll see backwards, it's the schematic of the court system. You'll see under specialized U.S. courts, the bankruptcy courts, okay? There's a tax court. And so what you'll find when they talk about subject matter jurisdiction, it has to do with the subject matter, okay? So, for example, bankruptcy. You can't file bankruptcy in a state court. Bankruptcy is a federal law. It must be filed in the federal court, and it gets filed in the federal bankruptcy court where you reside. So where you reside, you can't take that to, if you look at the blocks here on the diagram, you can't take it to the U.S. Court of Appeals. You can't take it to the U.S. District Court. You can't take it to the State Court of Appeals. You have to take the case to the U.S. Bankruptcy Court in Orange County, also in Santa Ana, a federal court. Now, another area, subject matter, is probate. Probate deals with the states, wills and estates, people dying and inheriting and so forth. Okay, that jurisdiction is reserved for each state. So any resident of the state who dies, if their estate is going to be probated, which means run through the court system where they gather all the assets, they read the will, they distribute, they pay the inheritance tax, distribute to all the heirs, and close the estate. That is going to take place in the probate court of the state where the party, the decedent, died, where he passed away. Okay, I'm sorry I have this itchy nose tonight, so bear with me on that. So that court, that probate court, has what's known as subject matter jurisdiction. Anything dealing with wills and trusts, someone passing away, and the probate of the estate has to be done in the probate court of that state in that county. So it would also be in Orange County. All right. So that's the third kind of jurisdiction. So just remember the three. Jurisdiction over the person, which is in personam, jurisdiction over the property or the thing, which is in rem or yem, and jurisdiction over the subject matter. All right? Okay, let's go back beyond that. So the jurisdiction over the subject matter. Let's talk. Let's talk about the federal jurisdiction now. Federal jurisdiction. A couple things about federal jurisdiction. There are two bases for the U.S. district courts to have jurisdiction. Okay, so from filing a lawsuit, which is, let's say, where it's going to start. You have a dispute and it's going to start somewhere. There are two bases for the federal court to establish jurisdiction. One is anytime it's a federal question. Now, when I say that, I mean they're actually going to file the initial lawsuit in the federal court. Okay, not that they're going to file in state court and it's going to go over to the federal court. This gets filed in the federal district court in the trial level. And that gets filed when there's a question of a constitutional question, so to speak, a question about federal law. So if someone's challenging a federal statute that may apply to a local business, so it may be a statute that deals with clean air, clean water, maybe an environmental rule, something like that, and there's a question in one of the parties' minds that you're taking away my rights that I'm guaranteed under the Constitution, that's a federal question. So that's one way for jurisdiction. The other way is called diversity of citizenship. Okay? Now, what is diversity of citizenship? It is very simply when the parties to a dispute live in two different states, then you can file in the federal court as opposed to the state court. Okay? So you can if I'm in California and I get into a dispute with another businessman in Arizona, I can file my suit in federal district court in Orange County because there's a diversity of citizenship there. He's a citizen of Arizona, I'm a citizen of California, and what you'll have sometimes is a race to the courthouse because maybe the Arizona party wants to have the case heard in Arizona and I want to have it heard in California. Now what can happen is both parties file suit and then the court has to decide where did the majority of the activity of the lawsuit and the interaction between the parties, if it was a contract action, where did that occur? Where was that more in California or more in Arizona? And so they're going to then instruct the court in Arizona is going to put a stay on their case and direct this defendant to go to California and defend himself in California. A lot of times nowadays contracts say if there's a dispute, it's going to be heard in this state. So a lot of times you don't even have that option. But that's diversity of citizenship. It's particularly common in automobile accidents where you have parties injured in different states, and there's a federal car, like a federal employee driving the car, that sort of thing. You've got this diversity of citizenship. They can go to federal court. They don't have to go to state court. Okay? So, and one other item too. The amount in controversy, that is the amount that's in dispute, the amount of money, has to be more than $75,000. So again, to reiterate, federal jurisdiction, to file your court originally into the federal system, which is the federal district court, you either have to have a federal question, which is a constitutional issue of some kind, or you have to have diversity of citizenship, where the two parties live in different states and the amount that they're fighting over is over $75,000. If it doesn't meet those, it has to be filed in the state court. Okay? So that is the way jurisdiction works. Now, I want to talk about the last aspect of jurisdiction, which deals with cyberspace and the internet. And so what you have is you have two parties who are in different states, right? And they do a business transaction over the internet. And maybe you have a company doing a lot of transactions over the internet. And so the question is, let's suppose I've got a little internet business that does 200 agreements or 2-month transactions with people a month. And the next thing I know, I get sued by somebody in Idaho, and I get sued by somebody in Nevada and Montana and Illinois and Massachusetts and New Hampshire. Where do we go? I mean, and not to mention that, how do I possibly defend myself in all those kinds of cases? So you can see where the court struggled with cyberspace, with business-to-business kind of internet business transactions, which are occurring all over the lot. And so I'm actually going to go ahead and read part of this to you because I think it makes it pretty clear. You'll see on page 33 it talks about the court using a sliding scale standard. And if you look over on page 34, you'll see where it really does lay it out pretty easily for you to understand. And it sees 3 different levels of business activity. And says 3 types of internet business contacts. And these are contacts between the parties. Substantial business conducted over the internet with contracts and sales, for example. So in other words, if you're doing contracts and sales like my example, then that would look to be substantial business conducted over the internet. Then some interactivity through the website. So a little, not quite as much contact, not as substantial activity going on, but I do have a website and some activities going on. That's going to be decided on a case-by-case basis. And then the last one has to do with passive advertising on the internet. So if it's not an interactive site and the person's just looking on the site and they see something's advertised and then they contact the people off-site, and maybe they're not contacting them through the internet, or even if they contact them through the internet and the people say, we'll send you an application, an order form, whatnot, that shows that those operators of that internet business don't really have deep-seated roots into California. They've got their advertising out there, but it's pretty much a passive thing. They're not really out there conducting the entire transaction once you get started through the internet. So it's those situations where there's a substantial amount of activity going on, and the court will then decide in any let's see, it's proper for the first category. The court would have jurisdiction there. And then for the third category, it's doubtful they'd have any. In certain situations, a single contact, though, can satisfy the minimum contacts, all right? So the court to assert jurisdiction, this is a state court now, a state court to assert jurisdiction for an internet business transaction that's in dispute, has to show that the other side had minimum contacts. You got to have at least a minimum number of contacts to attach the jurisdiction, right? And here's an example right below it. It's the Louisiana case of Daniel Crummy, and this, I would like you to read this, but basically what it stands for is that Crummy bought a mobile home, an RV, I guess it is, over the internet off of eBay from these folks whose names are, if it has it here, I'm not sure it really does have their name here. No, it does not. So anyway, the Crummies bought this RV. They live in Louisiana. They bought it off of eBay from people selling it in Texas. The people in Texas, as you'll read the case, told them it's like, grandma drove it to church. It's just in perfect shape. Nothing could ever go wrong with it. They barely get it home if they even got it home. I forgot the exact facts, and the thing breaks down, and it turns out it's got all kinds of problems. So now they sue the people file their lawsuit in Louisiana, okay? Because they live in Louisiana. They don't want to go to Texas to chase their money. They want to file in Louisiana. And the Texas people are saying, no. You can't sue. You have to sue us in Texas. Our business is in Texas. That's where we made the deal. You came over here, the vehicle was here, and you took it away, and that's your tough luck. You come back here to sue us. And the court said, no, not so. And the reason was, if you look at the bottom is that these people had a history of selling vehicles on eBay to remote locations, remote areas, meaning out of the state of Texas. And because of that, the court found that there were minimum contacts necessary to for the Louisiana court to attach jurisdiction to this matter. And the Texas court would not allow a suit to be filed there. It had to be Louisiana, because that's really where these people had done so much business outside of Texas. They have to come out of Texas and defend themselves for something like this. Okay, you're all right with that, I hope? So that's your whole idea of internet jurisdiction. It's if you can determine that there are substantial contacts, that the defendant has substantial contacts in your state, they're going to have to come to your state to defend. Okay? Standing to sue, the concept of standing to sue is very simple. Simply means that you have to be the one harmed. In other words, if you get an automobile accident and I hear about it, and I know you and I feel bad for you, and I want to be your champion, I can't just go down the street and file a lawsuit against the guy that hit you and be a party and be the only one in the lawsuit. In fact, I can't be in the lawsuit at all because I wasn't harmed. So standing to sue means you have to be the party who's got something at stake. You have to be the party who's been harmed, been injured, suffered a monetary loss, whatever it may be. It just can't be, your next door neighbor feels sorry for you, or he doesn't like what happened. He thought it was unfair and wrong, and you say, well, that's all I can do. I'm going to file a lawsuit on your behalf. Can't do it. He can't be the party in the lawsuit. He has no standing to sue. Okay. Now the last one deals with a concept called venue. Actually, venue comes before standing to sue, but venue. What is venue? Venue is the concept of a case should be filed and heard in the locale where the incident took place so that it has the local flavor. Flavor isn't the right word. So it has the view and values and culture of the local people. So to give an example, you have a murder. Well, an example would be if there was a murder in Orange. That case is going to be tried in the Superior Court in Santa Ana in Orange County. I'm at the city of Orange, but Orange County. It's going to be in that city. It's not going to be tried in Los Angeles. It's not going to be tried in San Francisco. The proper venue where that case should be heard, the locale, is in Orange County Superior Court because that's where Orange is. All right. Now, I don't know if you've ever heard of a change in venue. Lawyers will ask for a change of venue, which means move it away from that locale. And the reason is because of their concern of too much publicity, prejudice on the part of you can't get an unprejudiced jury, an impartial jury. An example of that is the Oklahoma City bombing case, which happened some years back. You may not have remembered it, but there was a fellow named Timothy McVeigh that blew up the Muir Federal Office Building, killed 168 people, including many small children in a daycare center there. And he was picked up, caught, charged, and they were going to have his trial. Well, the proper venue for that was Oklahoma City. That's where that trial should have taken place. That's the locale where the incident happened. Okay, and so it should be in that trial, in that courtroom, in that city. Obviously, there's tremendous prejudice. Can you really find an impartial jury in Oklahoma City? Probably not. And so what a judge will do, because that is the basis for appeal. So if the judge had said, he'd never said this publicly, but if he said in back his chambers, we're going to try this guy here because they're going to hang him in the highest tree, then he's not going to get a fair trial. Whether you like what he did or not, he's entitled to a fair trial. So most judges, because if he heard the case and McVeigh got convicted, the first thing he's going to do is appeal that, along with lots of other aspects of the case. And in appealing that, it's going to get overturned because they're going to find that it's not likely you could have found an impartial jury in Oklahoma City. That being the case, that case was moved to Denver, Colorado. Now, it made national news, and it was in the newspapers, and so to find a jury of people who've never heard of it is awfully difficult. And sometimes lay people say, are you kidding me? Everybody heard about the Oklahoma bombing case, and you could take them to New Hampshire, and people would know about it. That may be so, but the idea is an effort to try to not be in a situation where jurors can be really prejudiced and they'll pretend like they aren't. And you can still get that in Denver, but the passions are less likely to be as high in Denver as they are in Oklahoma City. So that would result in a change in venue, moving it from the locale where it should be to a new location. Okay? So that is the idea of venue. Okay. Let's look at, let me go back to the Supreme Court real quickly and just touch on the Supreme Court. The Supreme Court is an interesting institution. I've done a lot of reading about it, and I'm kind of a hobbyist towards the Supreme Court, I guess, kind of interested in it. It has become much more politicized than it used to be. If any of you keep track of any of these appointments and whatnot, it used to be that a president selected someone for the Supreme Court, and unless they were a serial killer, they got confirmed. It was kind of, these judges get appointed or nominated by this president, and then they have to be confirmed by the Senate through the advice and consent of the Senate. Well, over the last 20 years, 25 years, the choosing of a Supreme Court justice has become an extremely politicized thing. to the point where a lot of it came out of a couple of prior decisions. The most famous one is Roe versus Wade, which is the abortion issue, a woman's right to an abortion. And when Roe versus Wade was decided, it was a 5-4 case. There's 9 justices on the Supreme Court. It was a 5-4 case. And so the various groups, the Right to Life groups and the choice group, right to the choice groups, the choice groups want what would probably be a more liberal justice. And the Right to Life people are more conservative. They want a more conservative justice. And so you get this tremendous fighting back and forth as to who's going, and then the hearings can get really ugly and really nasty, and unnecessarily so. But that's what it's come to now. And so our U.S. Supreme Court currently is believed to be, what's happened is we have many 5-4 decisions, and they have a justice who they tend to like to identify as the swing vote. So he's the justice who you can't be sure which side he's going to come down on a given legal issue. And most of these legal issues you see that go to the Supreme Court have social ramifications and cultural ramifications and big business ramifications, tax ramifications. So it's not just here's a law, is this law constitutional or not constitutional? Okay, so it involves a lot of people's view of society. And so until recently, Sandra Day O'Connor, who retired about 2 or 3 years ago, Sandra Day O'Connor, she was appointed by Reagan. She was a conservative. But what happens a lot of times, these judges change their views when they get on the bench. And very often they'll move from being conservative to being more liberal or moderate. And Sandra Day O'Connor was a Chief Justice, first woman Chief Justice, who showed a willingness to move towards the center more and not be an ideologue only on the extreme right. And the court has to try to come to the middle anyway. And so she was the swing vote, and they always referred to her as the swing vote. Sometimes she'd go with the conservative group, sometimes with the liberal group. She's now retired. There's now a justice named Anthony Kennedy. And Anthony Kennedy was also is a Republican, appointed by a Republican president, viewed as being pretty conservative, but he has also shown an inclination to move to the left and more to the center and side with the liberals versus the conservatives. So we're back to square one again, it seems. We've got 4 recognized conservative judges who are the Chief Justice John Roberts, Samuel Alito, who was confirmed about the same time as Roberts, Justice Scalia, Antonin Scalia, and Justice Roberts, Clarence Thomas, who's the only black on the Supreme Court at this point, he and Scalia are the very, very most conservative. Then would probably come Alito, and then Chief Justice Roberts is on that side. The other side, you have Justice Breyer, then you have 3 women, Ginsburg, Sotomayor, and Kagan, and all 3 of those are considered to be extremely liberal also. So you've got those 4, and you've got Kennedy in the middle. Now, real quickly on the Supreme Court, as I said, not every case gets to the Supreme Court that gets appealed there. The Supreme Court gets about 9,000 requests for review every year. 9,000, if you can imagine that. And you'll see in your book, it's called a writ of certiorari. A writ of certiorari. It's spelled Certiorari. And except that I have it written down here, I probably couldn't spell it. And pronouncing it can be tough too. So sometimes I just say it really fast, like certiorari, and no one knows whether I'm pronouncing it right or not. But the idea is you file for a writ of certiorari, and the Supreme Court, they have justices that receive those and then decide whether or not they're going to accept the appeal or not. Okay. Now, a couple things. There's a thing called the Rule of 4. Okay. Now, you tend to think you have a Supreme Court, you have nine justices, right? So you would figure you got to have a majority to have an appeal accepted. Not so. You only need 4. It's a great trick question too on an exam. You only have to have 4, the rule of 4. If 4 justices say they want to hear this appeal, then it's accepted for review by the Supreme Court. Okay? Now, let me tell you the practicality of this, which may blow your mind. And it usually does blow most of my students' minds. The justices every year appoint law clerks. And who are law clerks? They are graduates from the top law schools in the country, usually extremely bright, intelligent men and women, who are interviewed by the justices to come work for them and help with their opinions and their research. Now, when I was in law school, the number 1 fellow in our class, a fellow named C. Boyden Gray, you can Google C. Boyden Gray, B-O-Y-D-E-N, Boyden. He was number 1 in our class. He was editor-in-chief of the Law Review, and he became the law clerk for Chief Justice Earl Warren back in the early 70s, I guess it was. And so, but here's what happens. So these clerks generally clerk for a year, maybe 2, and most justices have about 4 of them. So most of these men and women, young men and women, have come from Harvard and Yale, Stanford, the University of Michigan, the University of Chicago, Columbia, Berkeley, Cal. They come from the very top law schools, and predominantly, quite frankly, Harvard, Yale, Stanford, and probably the University of Chicago would be my guess. But those 3, the big ones, you all know: Harvard, Yale, Stanford. I would bet 85% of them come from there, either undergraduate or law school. But here's what happens: that those appeals get filed, 9,000. Who do you think looks at those? The law clerks. So you would tend to think that if you file an appeal in your case, you file to the U.S. Supreme Court. You want Justice Scalia looking at it, or you want Justice Kagan looking at it, right? No. It gets looked at by a law clerk, someone who can be anywhere from the age of 24 to 30, never practiced law. They're a law clerk. They're brilliant. They're very smart. But remember now, the issues that come to the U.S. Supreme Court are pretty intellectual. They aren't very mundane kinds of things. They take a lot of thinking, and they're very conceptual, philosophical, that sort of thing. So the law clerks are the ones who go through those 9,000 and give 400 or 500 to the judges saying, I think you should consider these, voting on whether to hear these. So they'll take this long brief and write up a page or 2 with a memo about the case and what they think the issues are. Now, both lawyers will have stated their issues about what the federal question is or what the appeal is that's coming from the state for whatever reason. But they'll put down what they think the constitutional issue is. The memo will recite, so the judge doesn't have to read the whole thing. It might have a paragraph on what the plaintiffs, on the appellants saying, and the paragraph on what the appellees saying, what they think the constitutional is in the law, and then what the issue, the law clerk thinks the issue, this comes to this kind of an issue. And the judge will look at that and see if it interests, basically 2 things. Does it interest him, number 1, and well, I shouldn't say number 1, but it's probably 1 and 2. And is there a serious, significant question that needs to have the Supreme Court pass on it and say this is right or this is wrong? So judges, some Supreme Court justices are interested in some land cases, and others might be interested in criminal cases. It just depends. But that 9,000 gets culled down to about 300 to 400, and then that 300 to 400 go to the judges, and they may agree to review 150 cases a year out of 9,000. That's all. And so cases get resubmitted. Okay, so they may come back the following year, but they're only taking 150 out of 9,000. Out of those 9,000, they'll assign their law clerk to do deep research on them, and then they'll come to the Supreme Court's conference room. No law clerks no one is permitted, but the 9 justices are in that room by themselves. There's no record, and in that secrecy, if you will, they discuss cases and decide. They've already decided, 4 of them have already voted to take the case, and now the research has been done, and each has their own position and feelings about it. they're going to go in and discuss it and decide what they think the right way is, and then they're going to vote. And when they vote, whoever wins, if let's suppose the four conservative judges and Kennedy votes with them, that's 5. And let's just say Breyer, who is on the liberal side, he goes with them too. So you've got 6 saying yay and 3 saying nay. Then the opinion, the majority opinion, will be written by either the Chief Justice of the court or whoever he assigns it to on his side. On the other side, if, for example, Justice Ginsburg, if she feels that they are completely wrong, she can write a dissenting opinion. Okay, so she can write a dissenting opinion, which will be published with the original opinion that the court writes. Then, if let's suppose Breyer goes over to the majority side to give them 6 votes to find the case in this respect, and let's say Breyer and Kennedy don't agree with the other 4 as to what they think the reason should be, the reason they're going to decide that way, they can write what's known as a concurring opinion. So you still have a 6-3 decision in favor of this party, but you may have 2 opinions coming down that are on the same side of we're fighting for this party, but 2 of the justices want to say why they think their reasoning is the reasoning it should be that way, not what the other 4 said. Okay, and then not to get too in depth, I guess I already have. Then lawyers look at those opinions, and if they see a concurring opinion that they can use in a different case, they'll pull that out, because even though that opinion, those 2 votes weren't the 4 that made it go that way, they still had legal reasoning that he can use to say you should continue to go the way this decision went. Now, but here's another probably somewhat of a shocker, and that is the law clerks write the opinions. The judges do not write the opinions. They edit them, but they don't write them. So the law clerks will sit down with the judge who's writing it, and they'll discuss the case and go through it. And he'll make points and point out to his law clerk what areas he wants him to really look into more detail, because he's got the briefs with all the law in them. And that law clerk or 2 law clerks will go dive into the books and do the research and come up with what they think, how they would write the opinion. Now the judge will tell them, I voted in favor of this and here's why. They don't just do it in a void, but this is why we're finding this way. And here's our reasoning, and he'll jot it down, and you need to go write me an opinion that backs up this reasoning. And so that's what the law clerks do. A matter of fact is I actually clerked for a trial court judge in Pennsylvania when I was first out of law school. Not because I was smart, just because I needed a job. And I had a job part-time at a law firm, and you could work part-time clerking for a trial court judge to help him with some of his opinions, because trial court judges write opinions too, not near with the the kind of depth and whatnot, the moment, the monumental outcome of a case, but they write opinions, and they require research and good law behind them. And I kind of a joke in a way to me, in a way, or kind of humorous, in that I had a judge, my judge, Tom Riley, the Honorable Thomas C. Riley. I went into his chambers one day because we'd go sit down and talk about cases, and he handed me a yellow legal pad, and it was completely handwritten by him, and it was 20-30 pages of handwritten language. And he said, Clay, I'm not going to let Joe Smith win this case. He's wrong. I know he's wrong. I know what the law should say, and I am going to find against him. He said, but I want you to take this opinion, which I've already written, and you'll see I've left blank spaces there where you can write in the case names, because when you write a legal opinion, if you've ever looked at one, you'll have the narrative that the judge is writing, and then you'll have a couple of case citations, they're called, which are cases that stand for what he wrote above. So basically this judge, and it wasn't like he didn't know the law. He knew the law, but he just didn't have the cases. But literally, instead of me writing the opinion, he had written it, and my job was to go out and dig into the research and the law books and find the cases that I could plug in there to substantiate his opinion, which wasn't that hard to do, but still, it was a little unique, because usually you would write the opinion, or he would write parts of it, and you'd go find cases for it and stick them in and so forth. But here it was written. I mean, we didn't change much of anything in this opinion. We just plugged cases in. So it's not the way the public thinks it works sometimes. And also, as a quick aside, occasionally the justices have been known to send a law clerk out to lobby with another law clerk from another judge, trying to get that law clerk to talk his judge into going along with him. So you'll find that there's all kinds of things going on in the Supreme Court behind the scenes. But again, these are extremely bright people. They're very thoughtful people. They have a strong, I think they have a strong moral sense of right and wrong. They have a very global view of the country, of the Constitution, of our history, of our traditions, of our values. They certainly know the law pretty well. I'm really sorry about this. I've got something itching. But in any event, they are very, very capable people. What really gets the Supreme Court in trouble, if you will, or what really gets the public riled up, is that in today's world we've gotten very polarized in our views of what's most important. Is it social issues or economic issues? If you had to kind of boil it all down, I almost think that's what the election was about. It was the Democrats thought social issues should be dealt with first, and the Republicans felt economic issues should be dealt with first. You know, get the economy going, get business growing, and so forth. And over here you've got, what about Medicare? What about Medicaid, and so forth? Neither side was going to bail on that other aspect of it. It was just which one were you going to make a priority. Okay, and so the Supreme Court, the Supreme Court had that decision with the Obamacare, and they came out and found that Obamacare was constitutional, and there were many people who didn't think it was constitutional. And Justice Roberts, who was the Chief Justice, who was known to be very conservative, surprised everybody by coming out and saying that he had voted in favor of upholding Obamacare as not being unconstitutional. And most people didn't think, particularly a lot of lawyers, didn't think that it really could stand the test. Because one of the things that it called for was telling people you have to buy insurance, and if you don't buy it, you get fined. It's like someone saying to you, you have to go buy a lawnmower. Well, I don't want a lawnmower. Well, you got to buy a lawnmower, and if you don't buy it, we're going to fine you $500. So a lot of people thought that was unconstitutional. And the way that, as I said earlier, the way the government regulates and manages us from a business standpoint is through the Commerce Clause. And that's how Obamacare was first presented, was through the Commerce Clause, saying that they had the authority to regulate the way healthcare was managed across the country. Well, the reality is, telling people in the law that you have to buy something is not commerce. It's your government telling you to buy something. Now, the way that Roberts and the majority got this thing got it by and found it constitutional was they turned around and said it's not interstate commerce, it's a tax, and Congress has the right to tax. In other words, they're saying if you don't buy the insurance, you get taxed $500. If you don't buy the lawnmower, you get taxed $500. Personally, I think it's a play on words. I was shocked when Roberts came out the way he did, but you know what? That's the law. That was the last word on it. That's the law. So that's the Supreme Court, and I'm getting way over here, but it looks like we may be doing some 2-hour lectures here. Hopefully I can keep them somewhat interesting for you. Okay, so that pretty much does it for the court system. And so now what we're going to do is we're going to go over to page 40. We're going to go to page 40, and that's section 4. And it's following a case through the court system. Okay? And so I want to take you through it. It's you'll see why I like alternate dispute resolution when I take you through this. And I think I'm going to try to take you through it pretty quick. And I'll tell you why. Because what I want you to look at on page 53, why don't you just put your pencil in there or a marker in there, you can flip back and forth through it. And it's got a It's got a diagram of stages of the lawsuit. Okay? But I'm going to take you through from the beginning, but just kind of have that to one side. I've actually got a copy of it here for me, so that I can refer to it. Okay? But I also want you to kind of go through from page 40 and really just kind of look at the chapter head and the section headings. Remember, as I said, I really recommend that you have paper with these written in and then have gaps where you can put notes in, because that's what we're going to do right now. We're going to kind of go through it this way. Okay. All right. So looking at the idea of procedural rules, I'm not going to take any time on that because we talked about that last time. And that is, you have the substantive rules and the procedural rules. And the procedural rules are how a case is processed through the system. The substantive rules are the law related to the activity or the conduct of the person, be it criminal because of conduct, be it an activity on the civil side where you've got a lawsuit or a dispute over a contract. Okay, there's various laws that apply to a contract. One, for example, is that the sale of real estate requires a written contract. You can't have an oral sale of real estate. I mean, you shouldn't. You could on extremely rare situations, but the basic law, statute of frauds says that an agreement for the sale of real estate must be in writing to be enforceable. That's what the law says. Okay, that is the substantive law. The procedural law is, let's say you have a contract for the sale of real estate, and there's a breach, and now you take that into the courtroom, and that's what page 53 is about. That's telling you the procedures, the stages that go through here. Okay. Now, what I want to do first, though, is you're a businessman. You have a small company. You provide a product for your customers, and you have, let's say you provide keyboards or monitors. Let's suppose your company makes monitors, makes a whippy-doo monitor that you've been able to get a market niche for, and you sell your monitors for $200 a crack. Okay, and so you enter into an agreement with somebody in California here. They're going to buy 10 of your monitors, okay, for $2,000, and you ship the monitors and they don't pay you. So now you have to file a lawsuit to try to get your money. Okay. So what you have to do, what you do first of all, is you go to consult a lawyer. So you go to consult a lawyer, and when you go to talk to him, first of all, in getting a lawyer as a business person, you want to make sure you get someone that has a business law background. As I said earlier, the law is highly specialized, and so in today's world, there's business lawyers, there are family law lawyers, there are wills and estate lawyers, personal injury lawyers, medical malpractice, medical device injury lawyers. I mean, so you want someone who's does business litigation work, and you want someone who does litigation work. Okay, so you go talk to him, you tell him about your lawsuit, you consult with him, you tell him what the whole situation is about, you explain the event to him. Okay, and during that time, he's going to be, what I did when a client would come in, I would listen to what they had to say. I would make mental notes and make notes on paper. And with my background and training, when a client would first come in and start telling their story, it eventually falls into a category and a subcategory and a subcategory. And so I begin to know exactly what area of the law we're talking about. Now this is not very complicated. You're talking about a commercial transaction between two merchants. You're talking about a contract. You're talking about the sale of goods, and you're talking about a breach of contract, and you're talking about money owed, and that's about it. But in most cases are much more complex than that, and many more moving pieces. But in any event, you talk to them, then your client, as the business person, you want to know what this is going to cost. Okay, so you can hire a lawyer in a couple of different ways. One is on an hourly basis. So lawyers have an hourly fee they charge for their work. And another one is on a contingent fee basis. All right, and the third one is on a per project basis, or a per item basis. Okay, let me A fixed fee, hourly fee, or contingent fee. So a fixed fee, what's a fixed fee? A fixed fee, for example, would be an adoption. So like when I did adoption work, I had a flat fee of $1,000. With the work that went into it, I estimated what time it would take, and I would quote $1,000. On a contingent fee basis, that tends to be mostly in personal injury work. Is where you get accident cases, that sort of stuff, is primarily where you get the contingent fee basis. And then the hourly is more for transactional work, where let's suppose I was hired by this person to negotiate the agreement between you, who's making the monitors, and let's say you've got 3 distributors out there, and I've helped you put those contracts together to protect you as best I can. Now I'm going to charge you on an hourly basis. Okay. Now, when I first started practicing law some years ago, it's been 30 years. You know, a good hourly fee was $250, $300. Fees have gotten to the point now where they can be really egregious. I understand that there are firms that are highly specialized in specific areas, acquisitions, one thing or another. They're charging $1,000 an hour. Many of the bigger firms in Los Angeles now are charging $450, $550, $600 an hour. That's a lot of money, and small companies can't afford that. Hence my pitch that I'm going to give you for alternate dispute resolution, arbitration, mediation. But mostly contingent fee is done on it's basically considered on a success basis, meaning if I file a lawsuit on your behalf for personal injury, you were injured by somebody and I filed a suit in your behalf. If I win the case, I get a percentage of what money came in. If I lose the case, I get nothing. Now that's the bare bones contingent fee, right? That's not the way it really works for a couple of reasons. One, you're required to pay all the costs. And what are the costs? Well, in today's world, if you have a fairly significant lawsuit, I have one going now with one of my companies that I'm their corporate counsel, and it involves a construction project, and we haven't paid, in fact, fired a subcontractor because they were doing inferior work, and now they're suing us, and now we have to countersue them. Now the total amount that they want is $75,000, and the total amount that they've cost us is about $125,000. Now a case like that is going to go into Superior Court, and the lawyers are going to be charging an hourly fee for that. And a case like that can last quite a while. It can last a year. And it very easily could consume $25,000 to $30,000, easily consume $15,000 to $20,000 if you could get it settled. If you can't get it settled, it could easily go $30,000 to $40,000, over $70,000. Okay, so that's an hourly rate, though. That's not a contingent fee. That's not a contingent fee. So I'm kind of just giving an example of the expense. I tend to get right away as soon as I start talking about alternate dispute resolution and the cost of going through our civil court system. But here's the problem. You can have a lawsuit involving a personal injury case. The lawyer can have a contingent fee arrangement. Let's suppose his contingent fee arrangement is 35%. And let's suppose he wins you $100,000. Okay. Well, in most cases like that, you have to have experts. So you're going to have a traffic reconstruction expert often. You're going to have doctor, 1 or 2 doctors or more if you had several doctors treating you, if you had surgeries or plastic surgery, so forth and on. And you're going to need experts about your economic value, your lost wages and so forth. Those experts will easily cost you anywhere from $10,000 to $12,000 to $15,000. Truly. So let's suppose they cost you $15,000. Okay. So it cost you $15,000 for them, and then you have to, let's suppose your medical expenses were $20,000 or $25,000. So now there's $40,000. Okay, so now that $40,000 gets paid first. Okay, so the lawyer takes a third. Okay, he takes, let's say he takes 30% of the 100, so he gets 30. The experts and so forth get 15, Okay, and let's say the medicals were only 20. Oh, so what? Excuse me. What do you end up with? $40,000, $30,000? That's one of the gripes about contingent fees, and you'll read about that. And again, in the discussion board, I really do want you to Google using the keywords contingent fee issues, contingent fee outrage, contingent fee controversies, amount of contingent fee controversies, whatever, and you'll find articles in there, and I want you to read one or two before you write your discussion board so you can mention one of those as to what they say. And don't just take that it's too much, because you'll see when we go through the cases here how much time really goes into it. All right. Okay, so you've talked to your lawyer. He's going to quote you a fee. If it's an hourly rate, he's probably going to want, my example is a lousy example because I need to have more money involved. So let's say you're suing for $50,000. So take my case, 70 and 125. So our lawyer, for example, I hire the outside trial lawyers to handle the case for our company. So he wanted the $3,000 retainer to start with. So he wants $3,000 to prepare the complaint, to prepare the pleadings. Okay. So you go to the lawyer, you tell him the story, you set up the fee agreement, you sign a retainer agreement. You're required in California that there must be a retainer agreement. It specifically says what the lawyer's going to be doing for you and what your requirements are to do for him. Then he'll do a little bit of an investigation, perhaps get some more information and so forth, and then he files a complaint. And a complaint's a document that alleges all of the things that he's making the claim for. And there actually is a complaint, but I think it's in Chapter 1. Let me find it for you real quick. Okay, let's see here. This looks more like it's an opinion. Where's the case? I know that we've got a case filed here somewhere. Just give me a second. I think I can find it. Maybe not. Well, anyway, I can't find it, but it has all the allegations in it. Well, this is on page 25 is a criminal case, but it's not a good one because of the civil cases of one I'd rather show you. But I'll see if I can find one for you, and in fact I can probably find one and email it to you. You can take a look at it. It's pretty boring, but I can get it for you. So he files the complaint, and depending on the size of the case, the complaint can be anywhere from 10 pages to mostly by today, most of them are 15, 20, 25 page complaints. And you'll see the language gets repeated over and over and over again. It's another reason why I got out of the private practice of law. Talk about boring, it's boring. But it's the procedural requirements. Okay, you see, this is the procedural requirements. Again, this is why I like alternate dispute resolution. They don't have as many sticky procedural requirements. So you filed your complaint, and now you'll see here under complaint, defendant's notified of the lawsuit, which means he's served. I'm just going to run down through this now. He's served with a lawsuit, so he knows he's been sued. He's got to have notice. Okay, you can't get a judgment against someone if you don't give them notice or make an effort to give them notice. All right. Now the defendant then goes to his lawyer, and his lawyer can do one of two things. He can either file an answer. So you've got the complaint here and the answer here. Okay, those are your pleadings, complaint and answer. Now, if the defendant decides he doesn't want to file an answer, but he wants to joust with you a little bit, in other words, he wants to duel legally with you, he'll file motions to dismiss. And he'll come up with various reasons why your complaint should be dismissed, why it's defective, basically procedurally what's wrong with it, or he may be saying that there's a significant piece of the evidence of the element of the breach of contract that you haven't alleged in here, whatever it might be. Very common for this to be done. And when it gets filed, now you have a whole series of processes to go through before you even get to the answer. So here again, you can spend thousands of dollars with lawyers preparing memos and briefs to argue over a motion to dismiss, and the answer has not yet been filed, and the case can go 6 or 8 or 10 months or a year, and no answer has been filed yet. because of this jousting going on between the lawyers, filing various motions for one thing or another, or filing the motion to dismiss. But let's say you get through all that, and now the answer gets filed. Okay, so you have the answer, and you have the complaint and the answer, and those make up your pleadings. Okay, you'll see at the bottom it says motion for judgment on the pleadings, and at that point, either party can request for the court to say, I've read these pleadings and I find in your favor, or I've read these pleadings and I find in your favor. Okay, that's a motion for judgment on the pleadings. Now, the only thing the court has to look at to decide whether or not they're going to find for one side or the other is what's on those two sets of papers. What's on this 25-page complaint and what's on this 20-page answer. And there's never enough. So judgment on the pleadings is rarely granted. Now, sometimes lawyers will file for judgment on the pleadings. And what happens is the businessman doesn't understand the legal jargon. And unless, and I'm not saying that your lawyer's going to cheat you. He may just think, well, I really do have a chance here. I'll tell you what, his chances are 1 in 1,000, maybe 1 in 10,000 that he's going to get a judgment on the pleadings. But it does happen, and it can happen, but it's rare. But if it gets filed, there you go again. For a judgment on the pleadings and a motion, the research and whatnot, you're talking another 2 or 3 months, maybe more, and probably another $10,000 or $15,000 in legal fees. Okay, and you haven't gotten to the merits yet. You haven't gotten to the dispute. You haven't had a chance to tell your story. You haven't had your day in court. Okay, so now we come up here. We filed our motion for judgment on the pleadings, and the judges said, no, I find there's enough here between the answer and the complaint that the parties have developed a valid legal dispute that must be determined, and we're going to tell you to proceed towards trial. So what the sides do then is they do what's known as discovery. Now, discovery is the black hole of litigation. Discovery it's like the national debt, the 16 or 14 trillion, whatever you see sometimes cartoons show this big black hole. That's what discovery is. That's where this system is dysfunctional. That is where businessmen need to avoid it at all costs, because it will cost you thousands and thousands of dollars to do discovery. And what is discovery? Discovery, first of all, is taking interrogatories. Interrogatories are written questions sent to each party to answer. Okay. Now, the whole idea with discovery is to find out all you can about the other party's suit before it goes to trial, so you can get a good assessment of what the case is worth, or what your chances are of winning or whatnot, or where your weaknesses are and where their weaknesses are and so forth. So you do it by doing interrogatories, and those have to be written and sent back, and then you do it through depositions, which is the main way it's done, which is getting parties and witnesses to come to your office, and you have a stenographer, and you question them about the case. And those depositions can take forever. A friend of mine, who was he's now the retired CEO of a bank in Orange County, when he was the CFO of the bank was purchased. He was involved in putting all the numbers together, the financials, one thing or another. Both sides had big law firms, and they sold the bank. And what often happens in business is the guys that bought the bank decided they didn't like the deal they got, and they turned around and sued under the contract, saying that the bank, the president of the bank, the CEO, had inaccurately stated the financial condition of the bank, and they were suing for breach of contract. My friend, at the time was CFO, eventually became CEO, and eventually saved the bank from going under and built it up into a really fine local community bank. He was in depositions for 18 days. Now, let me ask you, you're business people, you have jobs. Can you imagine what would happen to your job if you're in deposition for 18 days? And that's what can happen in these lawsuits. You can find yourself in depositions for 3 days, and then somebody else in your company's in depositions for 2 days, and somebody else for 5 days, and then you've got to have experts, so they take his deposition, and now your lawyer has to turn around and do all the same thing for the other side. He's taken 3 or 4 depositions. Those kinds of things can take another year, easy a year. If it's done in less than 6 months, I'll write you a check for $1,000. If you're going to do 10 depositions, it's going to take you darn close over 6 months for sure, and most likely maybe a year. So here you are with these depositions. Well, you take initial set of depositions, and then you file a motion for summary judgment. Summary judgment is the 2 pieces of paper, the complaint, plus all the talk, all the depositions, all the interrogatories that you've developed to that point. Now that isn't full discovery. That's the initial discovery. So maybe you've only deposed the 2 main parties on the other side, and maybe their accounting person, and maybe one other person. Just you get a pretty good feel of it. But all the peripheral witnesses, the experts, the doctors, what have you, you haven't deposed those yet. So you've only done maybe 25% of the discovery you would need to do. You do enough to try to take that plus the pleadings and get a motion for summary judgment where the judge says, you know what, I've heard enough from what these witnesses say, and looking at these papers, you don't have a case, you're out of court. And he grants the motion for summary judgment. However, that can be appealed. And many times motions for summary judgment are overturned. Secondly, if you ask me to use percentages, I'd say your chances of getting a motion for judgment on the pleadings is about 1%. It's about 5 to 8% for a motion on summary judgment. Okay, so if the other side appeals, it's probably going to get thrown out. And if it gets thrown out, now you continue on down this list of places we have to go. What's our time here? Hour and a half. Okay. This is where they call further discovery. Then you have the pretrial conference, and this is where we call it an MSC, Mandatory Settlement Conference, a pretrial conference, where you get together with the judge. He tries to twist your arm a little bit to get you to settle. He wants to know what the issues are in chambers, not in front of anybody else. And now the stenographer, he'll say, you know, McQuitty, you don't know what the heck you're talking about. That case is not going to fly. You know, that witness is a terrible witness. Or I've seen this piece of the documents. They don't add up. You know, what are you doing here? You know, and they'll put the arm on you. And depending on the judge, they can get pretty tough. And you know, they'll say kind of offhand things like, are you going to tie my courtroom up for 3 days for this thing? You guys need to go out there in the hall and settle it. Now, what that does is not just me, but both lawyers are thinking, ooh, I don't want to tick him off. Maybe I ought to go out and try to settle it. So they go outside, the judges, and with a good judge sometime in the pretrial will say, well, this is your weakness, that is your weakness. I don't know. These cases don't create doubt in our minds that we're not going to win. And we better make a deal if we can. Because, you know, money in the hand, you know, me getting 10,000 is better than getting nothing, and him paying 10 is better than getting hit for 50. So they kind of twist your arm, try to get you to settle the case, okay? And then you go to, if you can't settle, you go to trial. Now, here's the big one. You take your eye and run down the left column here of all these things, from going to see the lawyer, all the way down to motion for judgment on the pleadings, then go to the top, go all the way down, past discovery, to the pretrial conference, okay? 95% or more of all lawsuits are settled. They never go to trial. If you spend $40,000 in legal fees, okay, on a case, 30,000 to 30,000 of it would be for all this stuff before it goes to trial. And this is a sampling, and my numbers are just to give you a sample. In other words, you'll spend 75% of your legal fees, certainly 60%, on this stuff before a case, before trial, and the case gets settled before it goes to trial. Which means you never get to sit there in the witness stand and tell your story. You never get to the merits. You never get to tell a jury or a judge, if it's a bench trial with no jury, you never get to tell them what happened, what this person did, or you be able to explain, I did this because of that. You don't get to tell your story. You get to write a check. And in the meantime, you get to write another check to your lawyer. Now, wouldn't it be nice if you could avoid all this stuff and get into a room and get your case heard without all this mumbo jumbo and dancing around stuff and spending thousands of dollars for lawyers? No, if you're a businessman, you're darn right it is. I mean, the one thing I do as counsel for these 2 corporations I work for is when a case comes to us, I start running as hard as I can to get them into arbitration or mediation. I will kill myself to try to get us there, to keep it from getting filed in civil court. Because once it goes into civil court, which is what, block 2 or 3 there, once it gets filed, you're on this treadmill. You're on this railroad to nowhere. What it is a railroad for your business to spend a lot of money unnecessarily, not to mention the time. Okay? So alternate dispute resolution is the only way to go, and you'll see right here why all these things that go on. Okay, now you go to trial. Okay, and I don't know. It's looking like I might. Well, we'll see. So you go to trial, and you'll see on page. Here we go. Okay, we're back to page 40. You'll see consulting with a lawyer. On page 41, you'll see settlement considerations. Now, let me tell you about the settlement considerations. Myself, and I think good lawyers do, look at a case to see whether there is a prospect of, can we get it settled? Can you settle it right away? Okay. Some lawyers' attitude is, hey, I'll take your case, and we'll go get and kill the bastards, you know, and get you all riled up to fight and whatnot, because usually when a client comes into your office, a businessman comes into my office, and he's got a case involving a business dispute, he's ticked off at the other guy. He's really ticked off. Doesn't take much for me to light a fire under him, and pretty soon he wants to go to the mat. Now, that mat's going to make me a lot of money, going to cost him a lot of money, and I already know that the outcome is not going to be something he's going to be happy with. I already know we're probably going to settle. Okay, now am I going to do the best I can for him? Yeah, I'm going to fight like crazy. I'm going to take every deposition I can take. I'm going to lean on every witness I can lean on. I'm going to gather all the evidence I can get, documents and so forth, experts and what have you, to give him the best shot in the courtroom. But in the meantime, he might spend $30,000 or $40,000 for me to get him there. And then when we go to trial, I charge $1,500 a day for trial. So if we're in a 5-day trial, he's going to spend another $7,000, $8,000 plus. You know, what else? So, you know, is it worth his while to go to trial? And I take that back. It's probably not. That was. Now that I think about it, that was like 30 years ago. I'll bet these guys now are charging. They got to be charging $2,500 to $5,000 a day for trial. I'm going to check that out for you and see if I can remember, because $1,500 it wouldn't work today, I'm sure. So anyway, that was a lot of money 30 years ago. Anyway. So, you know, you want to look at you can look at the case at that point. You can say because here's the lawyer side of it. The client's ticked. He's come in. He wants to go to the mat. He wants to go to war. So he wants the tough guy. So if you're too easygoing and too placid about it, he may say, well, you're not the lawyer I want, because, you know, I need a guy. I like Larry H. Parker. I'll fight for you. I never get so sick of hearing that stuff. I'll fight for you. Every time you hear a lawyer talking about how he'll fight for you, let me tell you what, it's going to cost you twice what you thought. Okay, I'll fight for you. Yeah, you keep paying me, I'll fight for you. It's a bunch of baloney, trust me. So in any event, if the case can get settled beforehand or quickly, that's to your advantage, and you should press the lawyer to try to get it settled. Press him, press him, press him. And don't let him think that you think he's a weenie if he doesn't jump right up and throw on his armor and rush out to duel with the guy. And that's a problem too with litigation. Litigators like to litigate. It's like surgeons. They like to cut. They like to operate. So you go with something wrong with you, and a lot of surgeons want to cut. That's what they do. Lawyers want to litigate. That's what they do. So they don't necessarily thinking settlement, right? They're thinking about, let's get into this case and get going. And then what happens too is, and I'm getting a little long-winded, but I'm telling you, these are things you need to know about business. Then the lawyers start to get a thing for each other. They forget about you. Who's going to get the best of the other one? And pretty soon they're dueling, filing these motions I mentioned to you, a motion for this, a motion for that. Now you got to have a hearing, taking another deposition of this guy, filing a motion to dismiss this and that, and so on and so on. And they're going at it full speed, right? 24 hours a day. Who do you think's paying for that? You are. So you got two lawyers whose egos have gotten in their way, and they're fighting it out and duking it out, and one thing or another, they're going to show each other who's who, and you're paying for that. That's why the system's so screwed up. That's why the civil court system is so dysfunctional. Because the average citizen, the average everyday businessman can't afford what the system has to try to get a remedy for something he feels he's been wronged by in business. So that's why this is worth hearing, after all. Okay, so then you go through your trial. I don't know whether I should take you through the trial procedure. Sometimes people get interested in the strategies and the trial strategies and whatnot. I'll tell you, I'll leave it this way. Well, let me run it through quickly, and then you can email me if you want me to do a more lengthier. It would probably take me about 20 more minutes to do the lecture on the whole trial, but I do tend to get off because I've got experience in the area, and I've done enough trial work that I know what the strategies are, and different things happen to you during a case. It's a kick. It's an adrenaline rush, but there's a lot going on, a lot flying at you, and a lot of different strategies pop up, and people do things you don't expect, and it can be pretty challenging, pretty a lot of fun. But anyway, when you get into the courtroom, okay, the first thing you're going to do is pick a jury. And the judges will help you with picking the jury. Some of you may have been on juries before. If you haven't been in a jury, I recommend you try to get on one because I think they're very interesting. You can learn a lot, and I find that jurors are very serious about their job, and so they don't take anything lightly. The one thing I do find, though, is that you will get jurors who just don't get it. In other words, you can see a case and say to yourself, this is plain as the fingers on my hand, and you'll go into the jury room and somebody sitting in the back there, juror number 11, will just not be very bright and just not really get it. And there you go. And now the jurors are trying to talk that person or trying to explain to them or whatever. And if you get 3 or 4 together, you can end up with a hung jury because those 4 can hang together and refuse to change their attitude. So anyway, so you pick the jury first, and you ask them questions about, you're trying to determine whether they have any prejudices or whatnot, one way or another, and the judge listens to all the questions you ask them. And sometimes you try to develop a little rapport with the jurors if you can. You're on your P's and Q's, you're professional, you try to speak well, you make eye contact, you try to empathize with them, you try to read their faces, and you just try to have them accept you as a regular person who's just doing their job, and this is what you think your case is about, this is what you're going to prove, and we hope you'll give all our witnesses a fair hearing and so forth, that sort of thing. Try to connect with them. So then the jury gets impaneled, and now you have opening statements. So the plaintiff will make an opening statement to the jury telling them what his case is about and what he intends to prove. And he'll tell them, a witness is going to tell you this witness is going to tell you that. He can't testify for him, but he can summarize what they're going to talk about. When he's finished with his opening statement, let's say I'm defense counsel, then I have the opportunity to do an opening statement myself. But I also have the right to reserve that opening statement until after the plaintiff's case is done. So consider the trial split in half. You have the plaintiff's case, and the second half is the defendant's case, and then you have the conclusion, the summation. Okay? So the plaintiff, first he's making his opening statement. Then I have a chance to make my opening statement. But if I want to defer it, it's kind of like football flipping the coin, who kicks off and who receives. If I defer it, then I can give it before my case after the plaintiff is finished. Now, there's a couple of strategies that go with that. You may have the kind of case where you think that the defendant's case is not that strong. You think you can do a pretty good job on his witnesses on cross-examination when he's putting his witnesses on. And you think that if you give your opening statement after his case, because the judge has refused to grant the judgment in his favor, which he can ask for at the end of his case, and he says, no, we're going to let the defense put on their defense, that tells the jury, well, he didn't make out, I'm saying, Judge, he didn't make out the case. I've got a good defense here. And the jury's thinking, oh, the judge didn't just give it to him right then. He's going to he's going to let McQuitty tell his side of the story. So in that setting, I'll defer my opening and do it when it was my turn to present my case. Now, on the other hand, the other side, the plaintiff, and you'll know this, they have a witness who's extremely good or extremely competent or has got evidence that's extremely damaging or difficult and is going to really hurt your case, or it's certainly going to be a major hit in your case. A lot of times I'll do the opening statement then, and I'll reference that. Now, I can't testify exactly, but I might, for example, in a criminal case say, the police officer is going to say that he pulled out the gun and stuck it in the plaintiff's ear. Okay, well, that's not going to look real good to the jury, particularly if I can tell them in advance. Now, the police officer is going to say that my client pulled a gun on him and stuck it in his face, and that's not exactly how it happened. Now, we're going to show you how the gun in his face was totally by accident, and whether the gun came close to his face or not. That's going to be an issue for you to decide. So now, see, I've told them what's coming. The cop's going to say he stuck the gun in my ear. I'm going to say, well, he stuck the gun in, that he put the gun in his. And now, you choose your words carefully. He didn't stick the gun in his ear. He didn't stick the gun in his face. He put the gun towards his face. That sort of thing. And then I'll say, we're going to provide evidence through our witnesses that the gun was in the area of the officer's face, but there was an accident that caused the gun to get there, and we're going to tell you about that. So now they've heard it, and now it's not going to be a big shock where they're like, ooh, and then sometimes people's minds just go clam shut. That's it. So you prepare them. So that's where I would give my opening statement in advance and before I put my own case on. Okay, so we've got opening statements. Now plaintiff puts on his witnesses. He may have 2 or 3 witnesses, however many he may have. He'll have them in whatever order he thinks works best for him. And most often it's either the plaintiff goes first or he goes last. In some cases, if you have an expert, you might have your expert go last because his testimony, if you're the plaintiff, may be so strong and so emotional and whatnot. Sometimes in a murder case, you might put the expert on. Well, no. In a murder case, what they tend to do is put on a family member at the end for the sympathy side of it. But in any event, the witnesses will go on. He'll ask them questions. They'll answer them. Then when he's finished with that witness, I get a chance to go up and cross-examine that witness. Okay. Now, with your witness, you can't ask leading questions. Now, leading question is this. Now, Mr. Smith, wasn't the car red? That's a leading question because all he has to say is yes or no. So a leading question is one that only has calls for a yes or no answer. So, and you can't lead your own witness. So the plaintiff's lawyer can't say that. He can say, what color was the car? And the witness says red. Okay. Now, on the other hand, when I cross-examine, I can offer leading questions. And I can go to him and say, the car was really blue, wasn't it, Mr. Smith? That car was blue, wasn't it? Okay. And, that's a leading question. And, of course, he's going to say no. And I may have some reasons why that I can try to impeach him that he couldn't see, or a red car passed the blue car that had the defendants in it, or some such thing like that. So I can ask a leading question. But anyway, so you've got the direct testimony, then the cross-examination by me of the witness. That witness is excused. The next witness comes in, same thing. Direct examination, which is the plaintiff's case, and then I'm trying to punch holes in it. Okay. And one of the things that can happen is the plaintiff's witness gets up and starts testifying about something, and I've taken his deposition, and in his deposition, I might be following through the deposition, pages of the deposition here, and I have certain things highlighted, underlined, key things, and he says something that's different than what's in the deposition. Okay. Now this was given under oath. Okay. He gave this deposition under oath. So what the lawyer does to impeach him is I say, Mr. Smith, you told you told your attorney that the car was red. Is that right? Yes. He's going to say yes. He just said yes. I said, well, do you remember me taking your deposition about 3 months ago about this matter? Yes. And did you give a deposition that was stenographically recorded? And is this a copy of that deposition? And he'll look at it, yes. And I'm going to turn your attention to page 37 here. In answer to your counsel's question, you said, well, in fact, what you really do to make it really hit is you get him to read it. Okay, so here you are, read it. So then he gets to read it. And so when the jury's sitting there and the guy says, you know, Mr. Dream, what's on the car? The car was was blue. Are you sure? I'm sure. Well, then you're the defense lawyer. You go, well, which is it, Mr. Smith? Was the car red or was it blue? Were you telling the truth then, or are you telling the truth now? You see, you're impeaching the witness. Are there any other inconsistencies in here that we're not aware of yet? That's how you work them over a little, okay? And so that's impeaching the witnesses. So then they go through their witnesses. When they're finished, the plaintiff says he rests his case. When he rests his case, then he makes a motion for a verdict in his favor. I make a motion for the judge to dismiss the case. And 9 times out of the 10, the judge is going to do neither. But that's part of the procedural process. Okay, you ask, it happens, rare, but it can happen, that the judge, in all likelihood, he's not going to dismiss the case. It's sometimes in a criminal case, possibly, but not a civil case. So now we come to the judge will say, okay, Mr. McCurdy, now you can put on your client's case. Thank you, Your Honor. And if I didn't do the opening, I'll do the opening now. Tell them what we intend to show. Sometimes by hearing what they've already said, I can modify my opening to make it a little more apropos or a little more effective. And now I bring my witnesses on. I have to ask them questions that are not leading. And then my opponent comes in and he's asking questions of my witnesses and he can lead them. And he's doing the same thing. And if he finds something mistaken on the deposition, he's going to run up there and stick it under the guy's nose and show it to him and have him read it to the jury. So that's kind of the way it's played. All right. Now, at the end of my case, then, you can have rebuttal. He can bring another witness on. We do the kind of the same thing. He direct examination, I do cross. Usually it's 1 or 2 witnesses at the most. Rarely does it happen, but it does happen. It can be 1 witness or something. Or a witness can get recalled. But when he's finished with all that, then we're going to make motions for a directed verdict. It's called a directed verdict. And we're asking the judge to direct a verdict in favor of my client, the defendant, that the plaintiff hasn't proved his case and he's entitled to no money. And the plaintiff, on the other hand, saying, you should issue a directed verdict for me because McQuitty hasn't put up an adequate defense and he owes us the 50 grand and he ought to have to pay us. Okay? That's also rarely granted. And the reason it's rarely granted is because when you get to a jury trial, the judges 99% of the time are going to send the case to the jury. They're not going to having you go through all this stuff because you've got facts that are in dispute. We say it's blue, they say it's red. There could be 10 other things that we say it's this, they say it's that. And so they send it to 12 people who they hope have common sense that will discount those things they think are not correct and accept those things that are and come up with a verdict that's fair or that is the correct verdict given the situation. So that is, and so then when the judge rules on those motions, he, well, I messed up a little bit here. We each get a chance to do the summation. So at the end of all the witnesses, we each make a summation to the jury. That's where you see them in Hollywood and the TV shows, and the Perry Masons is the crescendo closing argument, they call it, the closing argument or summation. And can be a big deal, and guys can get a little theatrical and all that sort of thing. But the whole idea is to try to get the jury to love what they're saying and love them and love their client and love the case and go in the jury room and vote for them. So that's your summation and your closing argument. And then the judge is going to read the law to them. And he's going to, he's got law books there that tell him exactly based on what the kind of case it is. If it's an automobile case, if it's an intersectional case, intersection collision. He's got a model that he reads from that tells him what the law in California is. So he tells the jury, you are to take this law that I give to you, and you are to look at the facts, and if you decide the facts make out this case, you come back with a verdict. If they don't fit, then you find in favor of the defendant. Okay, so that's what I'm giving you the law. and you are to follow this law, and you have heard the facts. So what McQuitty tells you about the facts, what the plaintiff's lawyer tells you about the facts, what I tell you about the facts, because the judge will sometimes recap what was said on the stand in a neutral way. You're the one who decides on what facts are true and not true, what facts you're going to consider and not consider. But then you must apply them to the law. And there are cases where juries don't really want to come to the verdict they have to, but the law makes them do it. And that's an example of the system working well, because the law has made them come to that conclusion, because that's what the law says and that's what the facts show. So then your jury goes out to deliberate. They may have a question. They may come back in with a question, in which case everybody's got to come back into the courtroom. We lawyers usually wait somewhere nearby. Guys have been known to wait in their offices. Guys have also been known to wait in one of the local taverns for a beer. After all, you've fought through a 2 or 3 or 5 day trial or a 2-week trial, and your work is done. It's up to the jury now. So sometimes usually not with your opponent, but it's bad form, who may be a friend of yours, by the way, but you go with your office staff, or you go with a couple of guys you know and talk about the case, and then they'll call you over if they have a question. Everybody has to be back in the courtroom, all the parties, everybody. So then the jury deliberates. They can deliberate 2 hours, they can deliberate 2 days, they can deliberate 2 weeks, depending on the size of the case, the complexity, whatnot. They come back with their verdict. Now, if they find whoever they find for, the other side will ask that the jury be polled, P-O-L-L-E-D. Polled meaning they have each juror stand up individually and say, "Is that your verdict?" The idea being that there might be one juror who really was overwhelmed by the others and decided, okay, I'll vote for it. And then it really bothers them. They get up and say, "No, that's not my vote." And so in cases where you need a unanimous decision, the case is gone. I mean, now you're going to be doing a new trial because you got one juror who, for whatever reason, has backed out on the verdict, and it's not unanimous. Now, I will say, though, in California, so you know this, in a civil case, a jury of 12, it only takes 9 jurors. Okay, so it only takes three-quarters of the jury for a conviction, for an award in a civil case. So I actually served on a jury, and we actually ended up with a 9-3 verdict. We actually had 3 people sitting there who didn't who found liability on the defendant, which we didn't think was there. So you only need 9 in a criminal case. You need a unanimous verdict by the jury. It's got to be unanimous. The jury is polled, and that's their verdict, and that's the end. And nowadays, a lot of times, the lawyers will wait out in the court outside, and they're allowed to talk to the jurors if the jurors want to talk to them. Jurors don't have to. But the jurors will talk to them, tell you what you did wrong, what you did right, why your case didn't work, and so forth. And then after that, you have post-trial motions, and so you can file a motion for appeal. During the course of a trial, evidence might be let in, you object. After you object, you'd say, "Please note my objection for the record." That means you've taken an exception to that ruling, and that's one of your basis for appeal. So you'll find lawyers in a weak trial, there'll probably be 15 or 20 exceptions to the ruling. In other words, an objection, it was overruled, and you'll say, "Your Honor, please note my exception for the record." So you're taking exception to what the judge did, and that's one of your appeal points. So when you get the printed transcript of the entire case and you're preparing for your appeal, you're looking for those 15 and seeing which ones you think really are worthwhile, that you might have an appealable issue for. So you filed a motion for appeal. Most times in today's world, the lawyers who tried the case don't appeal it. Most of the bar is divvied up to the point where you now have an appellate's bar, so to speak, where lawyers that just write appeals will come in. They get hired to come in and prepare the appeal. So now you can see the expense that's going on if you have to appeal. So that's why big companies have a huge advantage over small companies, because big companies can afford to do this. They can afford to spend now another $40,000 to have the appeal process. Now, about the appeal, what happens at the appeal is they make what's known as the record, and the record is the notes of testimony, which is the stenographer sitting there typing down every word that's said, word for word. She doesn't miss anything, word for word. Uh, and that's why sometimes you'll have lawyers say you need to answer that because you can't just nod your head. She can't type down nodded head. She has to put just words. And so sometimes you get kind of crazy people sometimes, and the person keeps nodding your head, and you'll say, Mr. Smith, I told you've got to answer the question. Like the record will show that the defendant is nodding his head. And he's nodding his head affirmatively, and you have to put it in there for him because he's too stupid to speak for whatever reason. I mean, you have all kinds of folks in some of these trials, some of these cases. In any event, you have this record, and so it's really just it's a notebook. I mean, it's going to be thick. I mean, a big trial is going to have 5 or 6 of these, okay, with every word said by every person that took the oath and sat on the witness stand. And you have to pour through that. Now, what the judges do is the judges pour through that too. Their clerks do. Their clerks go through that. Now, you've got the notes of testimony, and you have all the documentary evidence. So photographs, plot plans of land or what have you, engineering designs of machinery that broke down, whatever it might be. A friend of mine had a huge boat case. The guy had a 200-foot yacht he had built and had all kinds of problems. And they had all the designer drawings of the boat, and they all go back to the jury room. I'm sorry, take that back. They all go with the record to the court. And the appellate courts do not hear any witnesses. So no witnesses come to speak to the judges. They are just going to make a determination. And the idea here then is they're not influenced by the people's demeanor. The jury decided from the person's demeanor, in addition to what they said, whether they're lying or not lying. And so in an appellate situation, the court doesn't want to be influenced by demeanor. They want to look at the words, and that's all they want to look at. They want to look at the photographs and the evidence and the words, and based on that, determine whether they think the jury's outcome was appropriate or did the jury miss something. So that is what you get, and appeals are very expensive. You have to print the record, and when I say print the record, the notes of testimony, which often come in almost like a binder, they have to go to a printer and be printed. I mean, it's outrageous, but that's what happens. They have to be printed, and you may have to give the court 5 sets of them. And on a decent-sized case, you may spend $30,000 on the printing, $20,000 on the printing on a bigger case. I mean, I'm talking about hundreds of thousands of dollar case, but still, it's $30,000. So that's that. And then the last part, after your appeals are over, then you have to, if you get an award for $40,000, let's say, here's a consideration when you first talk to the lawyer, because you need to probably know a little bit about your defendant. Does he have any money? In other words, you can go through this whole process, and if you get a judgment and he goes bankrupt, you can't collect. Or if he has no money anyway, you can't collect. So that's why in most lawsuits today, litigation cases, excuse me, they will always sue what we call a deep pocket. So you can have somebody that crashed into somebody else in the parking lot at Target, and the guy's got no insurance, no driver's license, and they'll sue Target because Target's got a lot of money, and say the design of the parking lot was wrong and it caused the accident. That's how my guy fractured his back. I mean, that's the way it works. So because Target's got money and this guy doesn't. So you get a judgment against the fellow who's got no driver's license and a beat up old rattle trap, and you get a judgment for $200,000. You can frame it, put it on the wall. You're not going to get any money. You got to get money from them. So the trial lawyers, the plaintiff's lawyers, they like to find somebody with money, and they will contort a case like you've never seen to try to include somebody who you and I would say, really? You think they should be responsible too? I mean, there was a tragic accident, and it affected me personally, I might say, because my office was down that way. I'm not sure any of you would remember this, but it happened on the 5 freeway down on Oso Parkway, where there was a a young mom with her mother in the car, three little children in the back seat. Uh, uh, One was 4, one was 3, the other one was maybe 2, quite not 2. And a big tractor trailer, they were on the right lane closest to the curb on the 5. And I happen to know, because I drive it a lot, that suddenly, without warning, that traffic will stop. And it happens more times than it doesn't. And it just stops with no warning of any kind. And I don't know what happened. I hope I didn't lose you here. Okay, I was worried there for a second. I thought we were gone. Okay, we're back. So anyway, these poor little children were killed, and an excellent law firm took the case and brought suit against the trucking company. Well, the trucking company was a small little operation, not very big, had little or no money. I think the trucking company, paid the limits of their insurance policy, which was, I think, $500,000. Maybe it was $1 million. But the family wanted more. 3 little children killed. They wanted more money. They sued the state of California because the state of California has deep pockets. Now, it's a tragedy that these little children were killed. The driver of the truck went to jail for a few years for manslaughter because he was driving he wasn't under the influence of anything. He just was driving too fast and not paying attention and probably wasn't familiar with the road. And so the argument was made that traffic backs up suddenly, quickly, boom, it stopped, and the city and the Caltrans has known about it, and therefore they were on notice and they should have done something. So it's a defective design of the highway and all this sort of stuff. That's because they were looking for a deep pocket, and the jury did not buy it and didn't go for it. And it's sad in one respect because of the tragedy, but from a purely emotionless consideration, who caused the accident? The trucker caused the accident for following too close behind. And the results were beyond tragic. But should the state be paying $10 million because the trucker hasn't got enough money to pay $10 million? I mean, that's the way it works sometimes. So anyway, so you got to be able to collect from your defendant. And so I tend to take my attitude towards towards my teaching here in this kind of law stuff is that I'm thinking more in terms of smaller companies. And when I say smaller companies that are doing 10 million in sales down to $1 million a year in sales, those are little companies. They can't afford $100,000, $200,000, $300,000 worth of legal fees. So they get into a case like this. Not to mention, remember now, 95% plus get settled. So why do you want to go all the way through to this battle? There are reasons why sometimes, but I'm not sure that they outweigh the cost. You know what I'm going to do here? This is going on 2 hours, which is pretty long. I haven't done ADR. I can do ADR really quick. So I will do it really quick next time. Please note the changes, particularly with the discussion board. I'd like you to do that Googling on capping contingent fees for trial lawyers. Trial lawyers is another key word to use. And put it in there and see what kind of controversies. There'll be articles people wrote saying they should or shouldn't. Think about those before. Don't just say, yeah, they should cap them. Because remember, there's more to it than just keeping those guys from getting money. Who's going to stop the government from capping how much you make next? By the same token, are there parts of those fees that the lawyer shouldn't get his 30% of? You know what I mean? Are there certain, maybe he should get 30% after everything else is paid, instead of getting 30% off the top. So there's lots of angles to it. You'll have to read about those and see what you think about them. Let's see what else we want to talk about. So, okay, so we've got next week, we're going to do, I'll be able to do ADR and admin really quick. Admin's quick. ADR is just going to be evangelical preaching on my part. But I don't think it'll take a lot to convince you that's the way to go. And then we'll take up the other chapters for the next session. So If you want more details on a courtroom, well, I don't know. I can kind of bore you to tears with some of the stuff, and so let's just conclude with this, and I'll look forward to talking to you next week. Take care.